Welcome back to Criminal Justice in Action, the podcast that examines the workings of the criminal justice system in England and Wales in practice. Each season takes a deep dive into a critical issue in contemporary justice. In Season 1, Rape on Trial, we explore rape and serious sexual offences in the criminal process. When it works, when it doesn't, and why it matters. Episodes may contain detailed and sometimes graphic accounts of physical and sexual violence, drawn directly from case files, witness testimony and court proceedings, including those involving adult and child victims. Listener discretion is advised. This is episode 2 of Criminal Justice in Action, Season 1, Rape on Trial. If you're new to the podcast, I'd recommend starting with episode 1. This isn't a drop-in, drop-out series. The cases covered and the issues they raise, they unfold over multiple episodes. For returning listeners, though, here's a brief recap. Episode 1 saw us in Crown Court for the start of Tariq's criminal trial. He's charged with 2 offences, 1 count of rape and 1 count of false imprisonment. We heard the judge's opening comments and instructions to the newly empanelled jury, known as judge's homilies. That was followed by the prosecution's opening speech, delivered by Mr. Neal, the barrister instructed by the Crown Prosecution Service. He introduced himself and defence counsel, Miss Roberts, who represents Tariq. Mr. Neal outlined the prosecution's case that Tariq raped Ruby, an 18-year-old college student, when she went to his office for a job interview and some training. That's the rape charge. After the incident, Tariq blocked the door, pressured Ruby not to tell anyone. This is the false imprisonment charge. Mr. Neal also previewed the defence case. He said that according to Tariq, he and Ruby engaged in consensual sex, initiated by Ruby after she'd danced for him, flirted, shown him photos of herself in swimwear. That according to Tariq, every touch, every act was expressly consented to by Ruby, who was not only consenting, but had initiated their sexual encounter. Tariq paid Ruby £20, believing that's what she expected. That was essentially it for day 1, which was brought to an abrupt end by a technical issue with the court's audio-visual equipment. On day 2, with the court's IT issues resolved, we heard Ruby's evidence in chief. That was presented in the form of a pre-recorded video interview conducted by specially trained police officers. Ruby was then cross-examined by Miss Roberts, live in court, but screened off from public and Tariq's view. We saw CCTV footage from Ruby's bus journey after the interview, where she's visibly distressed. We also heard witness statements from Ruby's mum and friends describing her emotional state after her training with Tariq. Her friends were all saying that Ruby wasn't herself that day, and she clearly didn't want to talk about whatever had happened. And then Carol, Ruby's mum, she recounted Ruby's initial disclosure that she'd been sexually assaulted and her later disclosure that she'd been raped. Finally, we heard from Detective Constable Elliott, the officer in charge of the police investigation. She described some CCTV footage that's no longer available, but she also gave a detailed account of what Tariq said during his police interview following his arrest. So that's where we'd got to in the case when court adjourned yesterday. Today, Thursday morning, we're back in Court 1 for day 3 of Tariq's trial, and we're fast approaching the end of the prosecution's case. It's already 10:30, but the jury isn't in yet. Just the judge, both counsel, Tariq and his doc entourage, the custody officer and the defendant's interpreter, and us, well, me. Remember Selina? The witness who was refusing to come to court apparently because the complainant Ruby had told her not to. Well, it looks like that's a miscommunication. A message from Selina that's been somewhat twisted in the course of it being passed from the witness service to the court, to DC Elliott, to counsel, and then finally to the judge. Ruby hasn't told Selina not to testify, which is how it's been interpreted so far. Rather, Ruby's asked Selina not to be at court when Ruby's own evidence was being heard. Selina is at court this morning, Mr. Neal's telling the judge, and she's ready to testify. Mr. Neal has alerted the court that he'll be making a special measures application so that Selina can give her evidence in court behind a screen, like Ruby did. Only now Selina's actually travelled to court and time's been set aside to get a special measures direction for the witness. Now Miss Roberts is telling the court that her client, Tariq, has told her this morning that he doesn't want Selina to give evidence. Now, in principle, it's not up to the defendant which witnesses the prosecution does and doesn't, can and can't call. In practice, however, they do have some influence, in the sense that if the defence accepts a witness's evidence, if they don't have any questions or challenges to put to that witness in cross-examination, then there's no need to call that witness. We saw that yesterday when the statements of Ruby's mum and friends were read into evidence on the basis that they'd been agreed, accepted, by all the parties, the prosecution and the defence. If you don't want opposing counsel to call a particular witness then, you can accept that witness's evidence. It doesn't guarantee that the witness won't be called, but it reduces the chances. The downside is that the judge will give that same direction that we heard yesterday, that the evidence in the witness's statement is true and accurate because the parties agree that it is. The upside, however, is twofold. One, the witness's statement is read out by the prosecutor in that flat, neutral tone, which can take all the emotive power out of the witness's evidence. The second upside is you know exactly what that witness's evidence will be, what's going to be said. It's all there in the witness statement, so there are no surprises, no being able to challenge or trip the witness up either, but no emotion and no evidential surprises that might be devastating to your case. The long and short of it then is that the jury aren't going to be hearing directly from Selina now. She's not going to be called. Her statement will be read into evidence instead. And the judge is, displeased. Her Honour's ire isn't aimed at defence counsel, who, says the judge, has been put in an invidious position by her client by virtue of his, quote, obstructive and uncooperative behaviour towards the provision of clear instructions to his advocate. This judicial telling off, then, absent the jury, is aimed squarely at Tariq. She can do little but register her dismay, the judge says to the court at large. This is not a game, she says sharply. Selina has been brought to court because you instructed your advocate that you had questions that should be asked of her. Plainly, that is not the position. The judge says there's little she can do but offer the court's apologies to the witness. She imagines that the fact Selina doesn't have to go into the witness box and answer pointless questions will be a relief. All of this is being translated to Tariq as he sits silently in the dock at the rear of the court. Back to business. Mr. Neal tells the judge that there are 2 videos to be played this morning, Ruby's visit to the chain store and a second one to the pharmacy. He's not going to play the 999 call now. He says he's taken on board what Her Honour said yesterday and he's content for the jury to have a transcript. The jury will see Ruby's spontaneity and consistency from that, he says, and they'll have seen her distress from her evidence yesterday. He'll begin, however, by reading Selina's witness statement into evidence. The jury's brought in and the hearing gets underway. It's 20 to 11. Given the previous issues surrounding Selina's evidence, you might be expecting to hear something rather more profound and contentious than what's actually contained in her quite brief witness statement, which Mr. Neal is now reading to the jury. Selina's statement explains that she'd seen a job ad for healthcare workers. She'd rung the number and spoken to a man. He asked her to send him her CV, which she did. He then rang her back saying he wasn't taking on care workers, but he did need someone for secretarial work. Selina wasn't looking to work office hours and so had declined, but he asked her if she had any friends who might be interested. She did. Selina sent Ruby the ad and Olivia. Ruby later told Selina that she'd got an interview. She wished Ruby luck and told her to call when it was finished. She did. Ruby rang her about 2 that afternoon. She sounded sad, says Selina. She told me to tell Olivia not to go anywhere near the man. Selina's statement goes on to say that she was in town with her friend Melody that day, so they all met up. Ruby, who's normally bouncing around, seemed quiet and upset. I kept asking Ruby what was wrong, the statement says, but she wouldn't tell me. Selena decided not to push it, to leave it until Ruby was willing to speak about it. She said she knew there was something wrong because Ruby didn't eat much. Selena says she messaged Ruby after asking if she was all right. Ruby told Selena she'd been to the police, but she never told her what had happened. Selena says she still doesn't know. Next, Mr. Neal plays 2 videos. The first is CCTV footage from the chain store. It shows Ruby waiting in the line at the tills and then paying for some pants and leaving the store. The second video is the purchasing of the morning after pill. We see Ruby entering the pharmacy. She speaks to the pharmacist, then she takes a seat elsewhere in the store. You see Ruby take a call on her phone, then go back to the counter and collect a packet. Mr. Neal tells the jury that the transcript of Ruby's 999 call will be distributed, which they can read themselves. It's not going to be read into the record. He now turns to the judge. That, Your Honour, is the Crown's case, he says. The judge looks to Miss Roberts. The defence will be calling the defendant, says Miss Roberts, but she needs to take instruction first. She asks if the jury might be sent out now in order for her to do just that. She estimates she'll need about 40 minutes. The jury's then sent out for a break. When they get back, we're going to be hearing from Tariq himself, which isn't rare in rape cases, but it's not routine. 45 minutes later, it's 11:35, and Tariq takes the stand. He's going to be answering questions through an interpreter, says Miss Roberts, because while Tariq understands some English, it's easier to respond in Arabic. Tariq confirms he's the owner of the company named in the job ad and that he'd set his company up about 2 weeks before Ruby's visit. Before that, he'd worked as a healthcare assistant at a hospital through an agency. He'd decided to set up his own agency, and the ad was to recruit agency staff for this new venture. When he's questioned about his first contact with Ruby, Tariq explains that he'd initially responded to a video on her WhatsApp status, the same video that contained the bikini image. When asked directly by Miss Roberts why he'd responded to that specific video rather than by contacting Ruby via their message thread, Tariq explains that it's easier to talk to someone that way on WhatsApp rather than having to scroll through a list looking for a name. His evidence progresses methodically through the messages exchanged before Ruby's visit, setting up the interview and so on, that he was going to train her in dealing with customers and answering the phone. Then to the day in question, he says he'd asked her to do some research for him into setting up another company, and then he left her alone in the office for about 15 minutes while he went to the post office. When he got back, he says, Ruby hadn't completed the task he'd given her. She told him, says Tariq, that she didn't know how to do the task. She only knows about dance, he says. He says Ruby then told him she didn't want voluntary work, she wanted paid work. I told her I could only give her £5 a day, and only more when the company was operational. How did she respond to that, asks Miss Roberts. She didn't, says Tariq. Did she leave, asks Miss Roberts. No, says Tariq. She started talking about personal things. You say personal things. What were those personal things, Miss Roberts asks. Tariq doesn't answer. Instead, he starts to cry. Loudly. The judge leans towards him. Tariq, are you all right, she asks. There's some water there. Have some water. Tariq doesn't take any water. Instead, he directly addresses the jury. He's pretty much incomprehensible because he's crying, wailing, gabbling, and gesticulating. The judge's gentleness is gone. She's immediately on him. Tariq! Tariq! He stops talking, but the sobs and gasps continue. This is not the time for you to make a speech from the witness box, says the judge. You've been asked a question and you've told the jury that she initiated it, and I think you said something about Spain. Now take a breath, try and compose yourself, listen carefully to the questions, just answer the questions, and this whole process of you giving evidence will be over quickly, and the jury will be able to hear your answers. Now, what was the rest of the answer you gave to the interpreter, please? Tariq continues to wail and sob and sniff as he talks to the interpreter in a strained, high-pitched voice. It takes a while. In fact, everything with this interpreter and defendant is taking a while. I've seen lots of defendants with interpreters, but this trial has been something else. It's been almost comedic at times. A short question from counsel takes an oddly long time to translate. Tariq then speaks to his interpreter for what feels like an age, and then the translator basically says yes, or some short answer that just doesn't seem to tally with the protracted conversation that led up to it. It feels like that's what's happening now. The suspiciously long discussion punctuated with wails and sobs from Tariq. Throughout all of this, Miss Roberts is leaning against her bench, arms crossed, just staring at the judge, looking deeply unimpressed. Eventually, the interpreter says, "She told me she went to Spain, then she showed me some photos in a bikini, and there was 2 other girls with her, other friends. Then she opened the photo and she zoomed in, then she got close to me, and then she showed me the picture." Having regained his composure, Tariq goes on to describe an increasingly intimate encounter where he repeatedly asked for consent to each and every progressive act. He sought consent to touch her hair, to touch her legs, to kiss her. Each request, he claims, was explicitly granted by Ruby. "I told her I wanted to learn how to dance," he says, "and she said, 'There's an easy dance I'm going to teach you.' I handed the phone over to her so she can choose the music." He talks about consensual kissing, stroking, touching, and eventually sex on a mat on the floor. Asked about the moment of penetration, Tariq says, "Then I was on top of her and coming with my penis inside, and then she says stop. Then I took it out immediately." "Was that the first time she'd said stop?" asks Miss Roberts. "Yes," Tariq replies. "At any stage before that point had she tried to push you away?" "No," he answers. "She was hugging me and kissing me." "So, after you stopped," says Miss Roberts, "what did you do?" "He ejaculated on her leg." "Did she say anything when you ejaculated on her leg?" asks Miss Roberts. "No," says Tariq. It's just after 1, and the judge halts proceedings so court can break for lunch. 2:30. We're back from lunch and Tariq's back in the witness box. Miss Roberts reminds him that they've reached the point where he's ejaculated on Ruby's legs. She's asking now what he did then. He's cleaned himself and Ruby with tissue. He'd asked her why she'd asked him to stop, and she said she wasn't feeling that well. "I told her, 'What we have done here, I will pay you,' he says. He told her he didn't have cash and they should go to the cash machine. He says he opened the office door and she followed. No, he says, he didn't at any stage prevent her from leaving the office. He didn't hold the handle to the door. He didn't put his foot against it. He didn't ask her to stay. They went to the cash machine, he explains. They passed people on the street at the pedestrian crossing. She's behind me, he says, speaking, smiling, and everything's good. All the way we are speaking, he says. Ruby was a couple of metres behind him when they first left the office, he says, but then she comes hurrying to me, to get closer to me. What happens when you get to the cash machine, asks Miss Roberts. I want you to show the video at the cash machine, says Tariq. She's standing there, near me. You will see her. She's looked at my pin. I'm thinking, why is she looking at my screen? And I think, why is she looking at that? And then I ask her what she wants, 10, 20, and she says 20 will be fine. Then, he says, he walks her to the bus stop and waits with her. They made arrangements for her to come back to the office later in the week, and she sent him a couple of messages later that night, but she deleted them before he saw them. He messaged her asking what she'd deleted, and later he says he sent some more messages about the job. So the next thing that happens is the police arrive at your address, says Miss Roberts. Yes, says Tariq. What happens? That high-pitched shriek is back. There are 4 police officers there, he says, and they tell me they arrest me for rape. He's crying and gabbling again. It was crazy and shocking, the interpreter eventually says. I didn't do it. He's taken to the police station. He's got a solicitor and an interpreter. He answers all the officers' questions. He admitted that they had sex. He's given the police his phone and its PIN number. I told them everything, he says. I didn't have anything to hide. In the same way that she put the defendant's case to Ruby in cross-examination, Miss Roberts puts the prosecution case to Tariq now. We've heard from Ruby that she did not consent, she says simply. Is that right or wrong to you? It's not correct, says Tariq. It's not correct when she says those things in her interview, Miss Roberts confirms. No. Some CCTV footage is now played on the court's screen while Tariq's still on the stand. It's footage from the street where Tariq's office and the cash machine is. It shows Ruby walking directly behind Tariq as they walk down a road past a restaurant. Miss Roberts points out that they've passed a couple of men as they walked. One last question, she says. We've heard from the police about there being a camera in your office. Yes, says Tariq. He got it from a friend, the day after Ruby's interview. He'd put it up on the wall but couldn't link it to the Wi-Fi. So you got it the following day, asks Miss Roberts. Yes, says Tariq, so I can see who comes into the office. Now, I know having an interpreter inevitably slows things down, but it's worth flagging up that so far Tariq spent just over 2 hours testifying. There was a break for lunch in the middle, but he has spent 2 hours answering Miss Roberts' questions, and he's not done. His evidence-in-chief is done, but now it's time for cross-examination, which starts immediately, and Mr. Neal does not tread lightly. Tariq, says Mr. Neal, good afternoon. I won't keep you very long. Just help me with this. First of all, when you wiped Ruby down after the consensual sex you say you had on the floor, do you say that that was an affectionate, attentive thing that you were doing to a lover after sexual intercourse? Yes, of course, says Tariq. I didn't see her response. If it's not her feeling good with me, I'm not doing that. It's not good doing sex with someone who doesn't want you. I don't need to force anyone. Mr. Neal cuts him off. I wonder if you could confine yourself to answering the questions that I put, all right? I was talking about you wiping her down. She was in a mess after happy consensual sex, albeit that she told you to withdraw on your evidence eventually, yes? Yes. He directs Tariq to the transcript of his police interview, which is in front of him on the witness stand. During this interview, says Mr. Neal, Tariq had explained his actions differently to the police. You say you ejaculated quickly, says Mr. Neal. I'll read it out to you. Quote, when I do that, when I started, I give my sperm quickly and she feel that sperm is come and she says stop. I already finished, so I stop. She want to stand up and I say wait, because sperm is on her. I don't want the mat to be dirty. I said wait, I have tissue and I clean her. Can you just explain that answer, please, asks Mr. Neal, because it seems to me that you're preoccupied with the prayer mat, is that right? No, says Tariq. I want to stand her. If she stands up, the mat'll be dirty. If she stayed, I can clean her, so she will be clean and the mat will be clean. I don't let her stand up because her clothes will be dirty. So you wouldn't let her stand up, says Mr. Neal. I didn't say that, says Tariq. You did say that, Tariq, says Mr. Neal. So after tender consensual sex, you become irritated with her. Wait, you say it twice according to the interview. Yes, says Tariq. Are you agreeing you were irritated with her? No, he's not. Mr. Neal moves on to the exchange relating to the job ad and the training. He's going through the text messages with Tariq, and then Mr. Neal asks, why does she need to do the training course if she's already been on a proper training course at college, please? Because he'll give her a certificate and it'll be on her CV, Tariq explains. Nowhere in this exchange do you tell her you can't pay her yet. No, says Tariq, I didn't tell her. Any particular reason you didn't tell her you can't pay her? Tariq explains that he'd told Ruby just to come and assist him, and that when she came, then he told her he wouldn't be able to pay her until he was operational. There's some toing and froing now about whether or not Tariq described her as being disappointed by this. He did. But Tariq's now saying he didn't say that. Mr. Neal proceeds to read every relevant part of Tariq's police interview and his answers in court today to demonstrate every instance where Tariq described Ruby as being disappointed when she realised there wasn't a paid position available. Mr. Neal then asks Tariq why, if he couldn't pay Ruby, he'd offered Selina a job at £9 an hour. "Well, I dropped Selina's application," says Tariq, "because she only wanted to work weekends." "Yes, but you were going to pay her, but not Ruby," fires back Mr. Neal. Tariq's evidence here is a bit confusing, but he seems to be saying that he'd changed his mind about the services his company was going to provide. So at the time he was talking to Selina, he would have been in a position to pay her, but that had changed by the time he saw Ruby. Mr. Neal now points out that it had taken Tariq 4 full days to respond to Ruby's message after he'd had her CV. "Why the delay?" he asks. "Because I'd changed my mind about the company," says Tariq. "Can I put a suggestion to you?" asks Mr. Neal. "You weren't going to get back to Ruby until you saw her status page, is that correct?" "Yes," says Tariq. "It is correct." Mr. Neal sounds surprised by Tariq's response. "Yes," says Tariq. "When I see this video, I remember that she'd texted me. When I remembered that she'd sent it to me before, then I contacted her." "Because you found her physically attractive," says Mr. Neal. "Not exactly that," says Tariq. "Not exactly that," repeats Mr. Neal. "Well, you tell me what then." Tariq repeats that it's because the video caused him to remember the application. Mr. Neal then asks again if Tariq found Ruby physically attractive. "I'm not very interested about that," he replies. They then go through the text exchanges, Mr. Neal compounding the point that at no stage in the messages has Tariq made it clear that there isn't a paying job available and that the company barely exists. He asks Tariq to explain again why he responded to Ruby by commenting on the picture rather than through the message thread. "It's just easier than scrolling through the message list," says Tariq. Now, you're dealing here with predominantly young women who are applying for positions. "Yes," agrees Tariq. "How many women does he think contacted him at this time?" "About 3, says Tariq. "So there are about 3 people ahead of Ruby in the conversation list," says Mr. Neal. "Yes," says Tariq. "So there's no advantage to using the status button rather than the conversation list." Again, there's a lot of toing and froing on this point, and it isn't something that Tariq agrees with, but Mr. Neal's point's been made. He asks Tariq how many times he watched Ruby's video and viewed her photos. Then it's on to the training and the promised certificate. This, Tariq confirms, would simply have been a piece of paper with the company stamp on it, which, according to Mr. Neal, wasn't worth very much. Tariq doesn't agree. They talk then about the content of the so-called training and that Tariq's asked Selina to let her friends know about the job and the training. "All right, let me cut to the chase," says Mr. Neal. "This training is a ruse, isn't it, to attract young females and in particular to attract Ruby into your office. There was no real prospect of you offering her a job, but you wanted her there because you were sexually attracted to her, yes?" "If I was," says Tariq, "if it was really that way, I would have told Ruby I will pay you £9 an hour." "No," says Mr. Neal. "You see, you didn't tell her anything about not being paid because that would have put her off coming, wouldn't it?" Tariq disagrees. "In Ruby," says Mr. Neal, "you saw a sexual opportunity, didn't you?" "No." "Why offer to pick her up and take her to the office?" asks Mr. Neal. "Because," says Tariq, "if I work with you, if it is on my way, go with me. I work in healthcare assistance. My girls, men, they don't have cars. They ask me for lifts when we finish work. You say this is about sex. I leave work at night with disabled people, with nurses, with healthcare assistants. If they want to hug me and dance with me, why not I do something with them?" Mr. Neal moves on. "On the eve of the interview, you tell Ruby not to forget to come, and then you ring her. After you've texted her, you're pretty keen to have her there, aren't you?" Tariq doesn't answer. It's 4:10. They've been at this for nearly 70 minutes. The judge asks Mr. Neal whether he's going to finish cross-examination today. No, he says. It's decided that this is an appropriate point to stop for the day, and court adjourns until tomorrow. 10:10, Friday morning, the last day of trial. Tariq's back in the witness box. No niceties, no warm-up, no reminder of where the witness has got to in the evidence. Mr. Neal is straight back to it. Did Tariq make a joke about Ruby not having invited him as a friend on social media, he asks. No, says Tariq. She's making that up, Mr. Neal asks. Yes. Then on to Tariq's insistence that Ruby had initiated their sexual encounter, that he'd read things, sexual things from her behaviour, from Ruby showing him the photos of herself, that she was flirtatious as soon as he got back from the post office. But Tariq's starting to pull back from this now. He's saying, well, no, it was when she started doing the dancing. Only when she held me, that's when it's come to my attention that she consents to sex. Mr. Neal points out, although I'm fairly confident we'd all noticed this ourselves, this isn't what Tariq told police during his interview, and it's not what he was saying in court yesterday. You're drawing back from your previous answers because you realise how ridiculous they are, says Mr. Neal. What's ridiculous about them? Tariq says quickly. He's getting frustrated now. Tariq looks away from Mr. Neal and appeals again directly to the jury, heatedly. He's telling the jury that after his arrest he didn't sleep at all. I have tension, he says, because there's an allegation against me for the first time in my life. If I wanted to make things up, he says, I'd go no comment. I would come to court and say everything I want to say. I wouldn't tell the police everything. That's the first thing. The second thing, he says, she called to the police the next day. Tariq's now cut off by the judge again. It's not for you to give a speech, she tells Tariq sternly. Answer counsel's questions. Tariq's answer now is that when he told police that he thought by showing him the photographs she was consenting, he meant he thought she was consenting to being friends, not to sex. Mr. Neal then takes Tariq slowly and systematically through every statement in his police interview and every answer he gave in evidence yesterday that contradicts Tariq's current position. But Tariq's sticking to his guns. He isn't lying. He hasn't just invented this at trial, made it up on the spot. He didn't think Ruby showing him the photos and talk of holidays was consent to sex. It was her behaviour, dancing with him, holding him, that indicated consent to sex. Given that she's coquettishly, sexually suggestively moved towards you, says Mr. Neal, enlarged the photo and it's clear she's interested, you felt it right to ask anyway, reasonably on your evidence, if you could stroke her hair before you did that. Yes. And she expressly agreed, yes, you can stroke my hair. Yes, says Tariq. Mr. Neal then painstakingly takes Tariq through every act, every stroke, every touch, every kiss, and so on, for which Tariq says he sought and was expressly given consent by Ruby. Mr. Neal pauses for a moment, and then he says, before penetration occurred, I count 7 highly specific questions that you say in interview you asked Ruby regarding what sexual things you were permitted to do to her. 6 if we discount the slow dancing. Can you touch her hair? Can you touch her leg? Can you kiss her? Can you touch her breast? Can she lie down? Can she undo her trousers? At each stage, you say you're asking a question seeking her permission. Yes, says Tariq. Mr. Neal pauses again, like he's contemplating something. Eventually he asks simply, are you sure? What? Says Tariq. Are you sure that happened? Asks Mr. Neal. That you were asking all those questions as the sexual congress proceeded between the two of you? I'm sure, says Tariq. Also, I'm asking her how much money do you want? If I want to do something, I ask. Thing is, says Mr. Neal, It doesn't appear to be a very spontaneous sexual encounter on your account. All these questions you pepper her with, it's almost like a tick box form. Did it happen? OK, says Tariq. I work in health agency, in healthcare and at the hospital. Before I can work for anyone, they do a course. It's about consent. Even I want to check the blood pressure. Even I want to check the blood sugar. I have to ask people if they want help before I touch them. My whole life is consent. I can't touch anyone without consent. If you touch anyone without consent, they will call the police. This is normal. Everywhere. You're telling us she's made a sexual overture to you, and yet at every stage, according to you, you're asking question after question. That's a lie, isn't it? To create the impression, the implausible impression, that you were absolutely fixated on consent and that you wouldn't do anything without her express consent for every single touch, every single manoeuvre in that sexual encounter. And it's rubbish, isn't it? No, says Tariq. Now Mr. Neal takes Tariq through the sexual acts themselves, where Tariq was, where Ruby was. That Ruby was pinned against the wall. No, says Tariq. That Tariq was on top of her on the floor. No. That she couldn't have made a dash for it like Tariq had suggested in his evidence. She could, argues Tariq, when my wife rang. Your wife may or may not have rung, says Mr. Neal. I don't know. But this is you throwing it into the mix to suggest that Ruby had a chance to escape if what you say is true. Do you mean I'm telling lies? Asks Tariq. Oh yes, that's what I mean, says Mr. Neal. The prosecutor then proceeds to put Ruby's version of events to Tariq, step by step, literally move by move, touch by touch. Tariq disagrees with everything Mr. Neal puts to him. And then, says Mr. Neal, sick of the struggle, you manhandled her onto that rug by the shoulders and laid her on the floor. Tariq laughs. Mr. Neal stops in his tracks. Is this funny? He asks. Yes, laughs Tariq. What you say to me is funny. It's funny, is it? In what way is it funny? You see my body size, you saw her body size, says Tariq. Oh, I try to overrun her. She's younger than me. She's gymnastic. This move, I can't do it, he's gesturing. She put her leg to her head, to the back, he says. I can't do it. She has strong legs. Mr. Neal seems incredulous. So, what you're saying, so I can be clear, is that it's completely unfeasible that you overpowered her and manhandled her because she's bigger and stronger than you. She's healthier and she's younger than me, says Tariq. She's stronger than me. Mr. Neal gives that a moment to sink in before he continues. You got on top of her and pulled down her trousers, her leggings, until you'd got access, didn't you? No. Then you raped her, penetrated her, while she tried to shield her vagina with her hand, didn't you? No, says Tariq. And when you finally penetrated her, then you had to work at it, didn't you? Then she screamed. Tariq laughs again, louder this time. Oh, that's funny too, Mr. Neal responds. What's funny? It's a building full of people. People would hear, says Tariq. If she say, ooh, all the people would come. Except if you turn your phone up to try to prevent that, which you did, didn't you? Tariq shakes his head and smiles. If she say, ooh, all the people would come, he says. We're covering ground quickly now. No, Tariq wasn't irritated with Ruby afterwards. Yes, he thought they were starting a relationship, that there was a future for them. No, he hadn't stopped her from leaving. He hadn't blocked the door. He hadn't told her she needed to finish her training. Why would he do that when she'd told him she didn't want the unpaid work, Countess Tariq? The object was to keep her in that room until she saw reason, says Mr. Neal, until she'd told you she wasn't going to report you, until she'd agreed to take money for what you'd done together. At this, there's a snort from the witness box. I look up from my notepad and Tariq's smirking. Funny again, says the prosecutor. Big smile on your face. You can explain that in a minute, but answer the question. This is all lies, says Tariq. It's strange, he says. It's not logical. Mr. Neal seems to reflect for a moment, like he's undecided. Then he says slowly, I don't want to make too much of this, but yesterday, when you were giving answers to my learned friend, you broke down apparently at various points. Today, a bit of a volte-face, a bit of a turn. You're finding things funny. I'm just wondering, why the change? Yes, I did, says Tariq. My daughter is at all times asking about me. When are you coming home? Yesterday, I just remember my family, and I just tell the truth. And today, you tell me things that are not logical, says Tariq. That telltale change in the tone and pitch of Tariq's voice is back. He begins to cry. That loud, sniffling cry, again. But you're starting to get upset now, observes Mr. Neal. Yes, sniffs Tariq. If you sit with me 5 minutes, you will know I am not a crazy person to do criminal acts in my office. On to the cash point, the quote derisory £20, the messages Tariq sent to Ruby the following day about the job and what and when he'd be able to pay her. Gaslighting her, says Mr. Neal, trying to make it all look matter-of-fact, making her doubt herself. And, Mr. Neal suggests, that Tariq deleted all his previous messages to Ruby, but kept the later ones so that if the police turned up, all they would see is normal text traffic as though nothing had happened. Albeit, says Mr. Neal, that Tariq was sending these messages at 4 a.m. in the morning. That, says Tariq, is because I was at morning prayer. And, says Tariq, he deleted the previous messages because when he'd called Ruby the day after the interview, she hadn't picked up and she hadn't texted. So he didn't want to keep in contact with her anymore, he says. If someone don't want you, you don't want her. This, Mr. Neal points out, doesn't explain why Tariq deleted only those messages before their so-called sexual encounter, but not the ones he'd sent after. You kept the later messages because they potentially exonerate you, suggests Mr. Neal. You did it because you raped her, you falsely imprisoned her, and you're lying through your teeth about it today. Tariq doesn't answer that. Instead, he says his phone is with the prosecutor, it's evidence. Nobody's asking to go through Ruby's phone to see if what she says is true or not. You didn't do your job properly, he tells Mr. Neal angrily. The judge interrupts. No, Tariq. What's your answer to the case that Mr. Neal has just put to you, that you raped and falsely imprisoned Ruby? No, Tariq says. No further questions. With no re-examination by Miss Roberts or any questions from the judge, Tariq returns to the dock. It's a little after 11:45. Tariq's just spent almost 3 hours being cross-examined by Mr. Neal. There's one more agreed fact read into evidence by Miss Roberts, and it relates to the CCTV footage shown yesterday of Tariq and Ruby walking along that street. It's basically just an official record of where the CCTV footage came from. And that, Miss Roberts tells the judge, completes the case for the defence. The jury's told to have a quick break and that when they're back, they'll get the first part of judge's directions, followed by closing speeches and then final directions. She's hoping, says the judge, that she'll be sending them out this afternoon to begin deliberations. It really is a quick break. The judge clearly wants to press on. When the jury's brought back in, Her Honour begins her directions immediately. She starts by reminding the jury that they have a different function to the judge. She's responsible for law, they're responsible for deciding the facts. She's going to tell them how to approach the evidence, including how to deal with the summary of evidence she'll give them later. She tells them they must assess the evidence critically, carefully, and without emotion. She says that in assessing a witness's evidence, they might find it helpful to ask themselves whether the witness was trying to tell them the truth, and if they were, whether their evidence was accurate and reliable. They'll want to look at what the witness said, how it was said, whether their account was supported or undermined by other evidence, and whether it makes sense. Don't speculate, she warns them. You're making decisions on the evidence you've heard. She speaks to the measures used for the witnesses, the pre-recorded video of Ruby's police interview and her being screened in court. She tells them that the purpose is to make sure the witness feels as comfortable as possible, that such measures are entirely neutral and they mustn't be taken against the defendant in any way. Tariq's interpreter too, that although Tariq speaks reasonable English, he has needed some help with words or phrases. She moves on to the so-called rape myths direction. Again, this is standard fare, you'll hear it in every rape trial. The jury's told not to let false assumptions or misleading stereotypes they may have about rape affect their decision-making in this case. They've taken a legal oath to try the defendant on the evidence. She tells them there's no typical rape, no typical rapist, no typical victim, that rape can take place in almost any circumstance, between different kinds of people, people who know each other, relations, strangers. There's no typical rape and no typical reaction, no typical response. Delay, she says. You must not assume that just because it wasn't mentioned straight away it must be untrue. The defence say that the fact the complainant didn't immediately say she'd been raped is because she wasn't telling the truth, that she'd had consensual sex with Tariq and was embarrassed and ashamed. The prosecution point out that this doesn't make any sense, and if it were true, had she kept quiet, no one need ever have known what she'd done and was now regretting. Remember, says the judge, people react to situations in different ways. She finishes by stating that a later complaint does not render an allegation untrue, in the same way that an allegation isn't necessarily true just because a complaint was immediately made. She's not expressing an opinion, she says. She's explaining these points so the jury will think about them. Distress, she says. The jury has seen evidence of Ruby crying on the bus. They've heard about her distress in Ruby's own evidence and from her friends. The prosecution suggests this distress supports their case, that Tariq had just attacked Ruby. The defence, on the other hand, suggests it's an act caused through shame and embarrassment. The jury needs to bear two things in mind when they consider Ruby's emotional state. First, there's no normal state. People respond differently. Second, it is possible for someone to put on an act if they choose to. If you are sure Ruby's distress was genuine, says the judge, then it may help you to decide whether the prosecution has proved its case. If you're not sure it was genuine, well, then it would not provide support for the prosecution's case. First complaint, she says. This relates to the 999 call and the statement from Ruby's mum regarding what Ruby told her Tariq had done. This, says the judge, is not independent evidence of what did or didn't happen between Ruby and Tariq. It may help the jury decide whether Ruby's been consistent and whether her evidence is true. She turns now to the defendant's character. They've heard Tariq has no previous convictions. Good character, says the judge, is not a defence, but it is relevant. He's given evidence, and his good character is a positive feature which they should take into account in his favour when considering whether they accept what he's told them. Second, the fact that he hasn't offended in the past may make it less likely he acted as the prosecution allege. The importance attached to Tariq's good character and the extent to which it helps in this case is for them to decide. Tariq has given evidence, she tells the jury. He didn't need to do so. He's entitled to sit at the back of the court and to say to the prosecution, you've brought this case, you prove it if you can. Giving evidence does not mean Tariq takes on any burden of proving anything. Certainly he does not have to prove his innocence, she says. The prosecution must prove him guilty. In cross-examination, says the judge, Tariq suggested a motive for what he says are false allegations. The suggestion is that she's had consensual sex with Tariq that she's then regretted. He's also claimed in his police interview that he had considered she may be going to exploit him. These points were not put to Ruby in cross-examination to answer, she tells the jury. They amount to no more than speculation by him. Even if you do not accept that Ruby did lie because she felt awkward, that does not mean you should in some way hold it against the defendant. Remember, the defence doesn't have to prove anything, she says. He doesn't have to make you sure that there's some improper motive. The prosecution have to make you sure that firstly, there is no improper motive for making such allegations, and second, that they are truthful and accurate. The defendant coming from the dock to give his evidence doesn't matter, she says. Tariq's evidence is to be treated the same as everyone else's. Her Honour confirms that the jury has a written copy of all these directions in their bundle. She now directs them to a second document in their bundles entitled Route to Verdict. Again, this is standard fare. The route to verdict sets out the individual charges against the defendant, gives the legal definition of each offence and a series of questions, a step-by-step guide, if you like, to the individual elements of an offence that need to be proved by the prosecution in order to convict. It's charged with 2 offences, rape and false imprisonment. This, the judge says, means the jury will be returning 2 verdicts and that they must consider the evidence against and for the defendant on each count separately. On each charge, she reiterates, it's for the prosecution to prove guilt. It's not for him to prove innocence. The prosecution will only succeed in proving the defendant guilty of any charge if they make you sure he's guilty. Nothing less will do. If after considering all the evidence you are sure that he's guilty, then you must convict. If you're not sure he's guilty, your verdict will be not guilty. She then carefully takes the jury through the necessary elements for rape, defining each term, penetration, consent, reasonable belief and consent as she goes along. She does the same for false imprisonment. In all, judges' directions take around half an hour. It's a lot for a jury to take in. It is. They're legal directions. They're presented as simply and straightforwardly as possible, but they cover a lot of ground. And especially when you're looking at the definition of particular offences, they cover a lot of complex legal ground. Don't worry, Her Honour tells the jury, it's not a memory test. The documents are theirs to keep until they've reached a verdict. Court now breaks for lunch, a shorter lunch than usual. Turn to 2, court's back from lunch, and Mr. Neal gives the prosecution's closing speech. It's half an hour long. I'm going to summarise it here. The prosecutor begins by acknowledging that real life rarely fits into tidy patterns. While it would be convenient to say Tariq simply lured Ruby into his office under completely false pretences, the truth is more nuanced. Yes, he misled her about paid employment and was clearly drawn to her WhatsApp photos, but as Mr. Neal puts it would be crass to suggest a cold premeditated rape was his intention from the off. He addresses what he calls a loose end for the Crown, that Ruby didn't leave when Tariq went to the post office. But, says Mr. Neal, she was a youngster looking for a job, and it would have been impolite to leave when she had misgivings. Mr. Neal then turns to what he says is the only contemporaneous evidence of Ruby's attitude while in Tariq's office. The video she sent to her friend with the message, "What the fuck? This is the office, guys." This, he says, does not demonstrate erotic interest. Mr. Neal talks about what he describes as the psychology of rape, not just the obvious power and domination aspects, but subtler attitudes. He highlights Tariq's tendency to treat Ruby as a commodity, that he thought she was expecting money from him in return for the sexual encounter, that he'd paid her. He compares Ruby's testimony with Tariq's. Ruby, he says, was restrained, consistent, and didn't embellish details. She wouldn't even speculate on how long the penetration lasted, he points out. In contrast, he says, Tariq's testimony was replete with instances of irrationality, contradictions, and self-pity. Mr. Neal then turns to the question of what possible motive would Ruby have for fabrication. The suggestion that she falsely claimed rape because she was embarrassed about consensual sex makes no logical sense, he says. Reporting would involve even more public scrutiny. He concludes solemnly, I said at the start of these proceedings that the Crown have to prove the essential ingredients of the two complaints on that indictment separately so that you are sure of them. I would respectfully suggest, he says, that we have done that in spades, in an overwhelming case, and I invite you to convict Tariq on both counts. Next, it's the defence closing. Miss Roberts begins by reminding the jury of the fundamental principle at the core of the criminal process. It's for the prosecution to prove the case against him, she says. That's the approach you have to take in any criminal trial. Tariq doesn't have to prove he's innocent. She also highlights that Tariq, as the defendant, enjoys the right to silence. He could have remained silent in his police interview. He could have stayed in the dock without testifying. He didn't. He chose to give his account. The defence position is straightforward. Sexual intercourse did take place, but it was with consent, or he reasonably believed she was consenting. On count 2, false imprisonment, she says, the question is whether Tariq prevented Ruby from leaving or whether she went willingly, as you saw in the footage. Then she addresses the emotional weight of trying a rape case. When the indictment was read out to you and you heard the word rape, your heart may have skipped a beat, she says. She acknowledges jurors might feel sympathy for Ruby, a young complainant, 18 at the time. They might have sympathy for Tariq, or, she says, they might have taken an instant dislike to him based on the charges. These are emotional reactions, says Miss Roberts. She asks the jury to put those emotions to one side. You've taken an oath to try this case on the evidence, she says, the evidence you've heard in this courtroom. So what of that evidence, she asks. The principal evidence, she says, is that of Ruby. They've heard from other witnesses who support her complaint, but only 2 people were there, Ruby and Tariq. Miss Roberts then pivots to what she portrays as problems, reasons for pause in Ruby's account. Despite Ruby's claimed misgivings and alarm flags, she still went to that office. When Tariq left her alone, she could have left if she wanted to, but she stayed, says Miss Roberts. Rather than leave, Ruby recorded a video of the office and sent it to her friends. She refers to Ruby's physical attributes compared to Tariq's, the point he'd raised in cross-examination. He's not a tall man, says Miss Roberts. He's not a big man. She was a stronger lady than him, and if he'd pinned her to the wall, she could have given him a swift kick in some intimate region and sent him to the hospital. She points to the timing and location. Weekday, 10 o'clock, busy morning, other people in this office block. If Tariq's intention was to assault Ruby, she says, he could have just as easily picked a Saturday or a Sunday, less people about, no one in the office to hear her screams. She suggests even Tariq's job ad was inconsistent with criminal intent. The advert's using his own telephone number, easy to trace, hardly sophisticated, hardly pre-planned. She turns then to Ruby's behaviour after leaving the office. She doesn't flee, she says. She continues to walk with him, doesn't stop anybody else and ask for help. Then Ruby goes to her friends, to a nail bar, to dinner. She describes Ruby's 999 call as devoid of emotion, of upset, of tears, implying this lack of audible distress somehow undermines her account, or at least contradicts or complicates the prosecution's evidence of Ruby's distress. As an aside, though, I want to remind you, of course, that the jury only heard about 5 minutes of that recording because the audio went kaput, and then Mr. Neal reconsidered it being played in full. The jury then has only been given the transcript, which means they're in no position to assess whether Ruby was or wasn't devoid of emotion, upset or tears when she rang the police. Anyway, let's get back to Miss Roberts' closing. She's reminding the jury of Tariq's good character. 40-plus years of age, he has no previous convictions, she says, and his consistent account that Ruby only said stop once his penis was inside her, and that when she said stop, that's what he did. Finally, says Miss Roberts, I'm not going to trespass or insult you by telling you what to do, if you should convict or acquit. That's a matter for you. You look at the evidence, and what you collectively as a jury bring to a case is common sense. That's the point of a jury. You look at the evidence and then you decide using your common sense. If you're sure, you convict, she says. If you're unsure and left scratching your head, if you're not sure, then you should reflect that in your verdicts in favour of the defendant. It's 2:45. No break in proceedings, we're straight on to the judge's summing up of the evidence. Judge's summing up is precisely what it sounds like. It isn't about rehashing every detail, it's about reminding the jury of the key points and the main evidential themes, highlighting disputed fact, credibility assessments and any agreed evidence. The judge's summing up often mirrors the route to verdict, which helps the jury to mentally organise the evidence in relation to each count. The judge presents the evidence even-handedly, avoiding any commentary that could sway the jury. If in the course of their summing up the judge does express a view, the jury is free to disregard it, and they're told this explicitly by the judge before the summing up is given. Now, you've just heard all the evidence. I'm not going to go over it all again now. Safe to say Her Honour covers both the prosecution's case and the evidence it called, as well as the defence case and all their evidence. She tells the jury plainly that Ruby's account is diametrically opposed to Tariq's, that they can't both be telling the truth, and that the jury's going to have to make a judgment call between those two accounts. Then she gives the jury its final direction. Members of the jury, she tells them, your verdict must be unanimous. That means all of you must agree. You should not concern yourselves with the possibility of a majority verdict. That is not acceptable unless and until I give you a further direction. You must strive to reach a verdict on which you all agree. The jury is then put in charge of the defendant, and an usher takes them off to the jury room to begin their deliberations. It's 4:45. So here we are, right back where we started, with me sitting in an eerily quiet court one at about 25 past 4 on Friday afternoon. Jury's out, and for whatever reason I'm still here, sitting in the public gallery, going over my trial notes and dealing with emails. Then there's that sudden flurry of activity because the jury's coming back, not with a question, with a verdict. Moments after the judge has taken her seat, the jury's filtering back into court. And all I can think is, oh crap. Why? Well, because I don't think Tariq's guilty. I'm sure he's guilty. No doubt in my mind, reasonable or otherwise, he's guilty on both counts. Maybe you don't agree. Maybe you're about to tell me that this is a case of one person's word against another's. How could I possibly be sure? Well, a lot of criminal trials reduce down to one person's word against another's, not just rape trials. Most criminal trials. It was him, it wasn't him, he hit me, I never touched him, or he hit me first. One person's word against another's. One witness saying one thing, one witness saying another. There's nothing wrong with one person's word against another's. Subject to a handful of statutory exceptions, and rape is not one of those exceptions, neither is false imprisonment. The exceptions relate to certain perjury prosecutions, treason. But aside from these very limited exceptions, there's no corroboration rule in England and Wales. What that means is, one person's word is enough. So long as the jury find that person's word to be credible and reliable, if that witness's evidence is sufficient to persuade the jury so that they are sure of the defendant's guilt, then one person's word is all you need. And having heard all of the evidence, I'm sure Ruby's a credible witness who's given an honest and accurate, a reliable account of what happened in that office. But what about the delayed report? Well, what about it? Most rape reports are delayed. Some victims take years to report. So what? And her mum told her, don't do anything tonight, report it tomorrow. So she took the money from Tariq, went to a nail bar and a restaurant. Again, so what? Stunned, shocked and trying to process what's just happened, looks like she's gone on autopilot to me. She also wept on the bus, bought clean underwear, cried at the pharmacist's while she was getting the morning after pill, went to her friend's and immediately showered. Everyone who spoke to Ruby that day knew there was something wrong. People who knew her and people who didn't. There were no gotcha moments in cross-examination, no trip-ups, no big revelations. Miss Roberts didn't ambush Ruby or attack her credibility or her character. She put the defence case to Ruby, as she should, giving Ruby the opportunity to accept or reject Tariq's version of events, which Ruby did. She rejected Tariq's version of events consistently, persistently, resolutely, and as far as I'm concerned, resoundingly. Compared with Tariq's almost 3-hour-long cross-examination by prosecuting counsel this morning, Ruby's 49 minutes in cross-examination a couple of days ago was pretty unremarkable, almost pedestrian. Cross-examination will doubtless have been hard for Ruby, given what she's talking about and given the purpose of cross-examination itself. But there was no showboating, no theatrics, no evidential traps or ambushes. In fact, nearly a full half of Ruby's cross-examination, was mundane to the point of being evidentially pointless. I still have no idea what bearing the position of the office door in relation to the stairs has on anything. In contrast, Tariq's performance on the witness stand was catastrophic. He sobbed, he wailed, he got angry, he laughed and he derided. If he was trying to win the jury's hearts and minds, I don't think he did himself any favour. And Tariq did another thing that, in my experience, doesn't tend to persuade juries. He over-denied. He denied Ruby's allegations to the point of his own account being incredible. First, he over-egged the consent pudding. Tariq's claims that when it comes to consent he goes above and beyond, that he's trained in consent, and that he sought Ruby's express agreement to each and every touch. It just doesn't wash. It might be what university consent classes model as consensual sex, but it's not what consensual sex tends to look like in real life, is it? And second, Tariq painting the complainant as some seductive temptress. Ruby wasn't just consenting according to Tariq, she initiated the whole encounter. But the idea that this 40-odd-year-old married man's been seduced by a slow-dancing 18-year-old college student expecting money for sex at a job interview that she subsequently regretted. Well, do you buy it? I don't. Another reason I'm so confident of Tariq's guilt? Miss Roberts' Hail Mary closing speech. By and large, there weren't crass appeals to common rape myths in Miss Roberts' cross-examination of Ruby. Yes, we got the why didn't you leave, why did you even go questions. Miss Roberts also tapped into reported expectations of how genuine victims react when she asked Ruby about what she had and hadn't done immediately after the incident. She hadn't raised the alarm when she got out onto the street. She didn't report it straight away. Instead, she went to a nail bar, went for dinner. But in closing, Miss Roberts' appeals to so-called rape myths and misconceptions, they were less subtle than they were in cross-examination. We still didn't hear any of the things that we're told are routine in rape cases. There was no, but members of the jury, did you see what she was wearing? What did she expect? No, well, Ruby's taken money for sex, so you can't believe a word she says. But we did get, he's not a big man, and why didn't she give him a swift kick in an intimate region? The old she didn't resist, so she must have consented, or at least it's reasonable to believe that she was consenting chestnut. So why is this same barrister who spent 50 minutes conducting a professional, courteous and somewhat remarkably unremarkable cross-examination, why has that same barrister now concluded her case by basically asking the jury why Ruby didn't just kick him in the balls? What changed? Tariq's disastrous performance in the witness box, that's what. Because as much as we're told that rape myths and stereotypical beliefs like this take centre stage in rape trials, you don't generally see them raised in practice. It's not that it never happens, it does. We've just seen it happen. But it's not routine, not in cross-examination and not in closing speeches. A routine defence closing focuses on the standard of proof and the juries need to be sure. If counsel ventures into rape myth territory, they only tend to do that in the strongest evidential cases. Hence my calling it a Hail Mary defence. It's a desperate, last-ditch, nothing to lose, throw everything and anything we possibly can at this defence, because the prosecution's case is compelling if not overwhelming. That's when you'll see rape myths explicitly brought into play, when the prosecution's case is strong. Something else I've noticed, as a defence strategy, Hail Mary defences don't tend to pay off. By my reckoning then, based on my experience in the courts, this jury should be convicting. So why am I suddenly panic-stricken by this jury's imminent verdict? Well, several reasons, but chiefly because it's so quick. It was only about 35-40 minutes after they'd retired that we got word the jury were coming back with a verdict. I haven't seen that before, not in a rape case, and it doesn't feel like that's a good sign. And at its core, this is a case of one person's word against another's. No injuries, no threats, no knife-wielding stranger leaping from the bushes, just two people, not well acquainted, alone in a room. He says she flirted, he says he repeatedly checked for consent, he says he's paid her the £20 she's asked for. She didn't raise the alarm when she left the office. She didn't report it straight away. He says this is a false allegation motivated by regret and embarrassment. And these are all factors, rape myth-based factors, that we are repeatedly told count against conviction. In fact, we're told these sorts of cases don't even make it to court. Then there's the fact that Ruby's 18, 19 by the time the case got to trial. According to the research, 18 to 25-year-olds are the age group most likely to report rape and least likely to see a conviction. And Ruby's black. Again, according to the research, as a cohort, black rape complainants are the least likely to see a conviction, even where evidential thresholds are met. In short then, according to the received wisdom, this is the wrong kind of rape with the wrong kind of victim, and the jury's been out for 40 minutes. So as the jurors settle into their seats, I've lost all confidence in this jury's ability to focus fairly and squarely on all the evidence before them and convict this awful little man. The clerk stands. Members of the jury, he says, have you reached verdicts on which you are all agreed? Yes, says the jury foreperson. On the charge of rape, do you find the defendant guilty or not guilty? Guilty. On the charge of false imprisonment, do you find the defendant guilty or not guilty? Guilty. To say I'm relieved is an understatement. Now I'm just cross with myself for momentarily buying into this popular mainstream discourse that tells us that when it comes to rape and serious sex offences, police don't believe complainants, prosecutors don't prosecute, and juries don't convict. The one that tells us that rape has effectively been decriminalised. But I wonder, what are you feeling? Surprised? Relieved? Shocked? Maybe even sceptical? Maybe you're thinking, of course they convicted, you saw the evidence. What are you on about rape myths, mainstream narratives, conventional wisdom? He's patently, blatantly and very obviously guilty. Or maybe you think I've managed to stumble across an exceptional case, a trial that shows the system can work in rape cases, but one which I've mistakenly understood as representing the norm when in fact it's the exception to the rule. Whichever camp you're in, this season of Criminal Justice in Action is for you. Join me in episode 3. We're going to do it again. We're going back to court. We're going to watch another rape trial. We're going to see for ourselves if Tariq's trial and the convictions that followed were a fluke. Because if it wasn't a fluke, if it wasn't exceptional, then maybe the story we've been told about rape in the criminal justice system needs a closer look. If you've been affected by any of the issues raised in this episode, please visit our website criminaljusticeinaction.com for information about support. Criminal Justice in Action is a Scrutiny Media production, researched, written and presented by Dr. Candida Saunders, edited and produced by Candida Saunders and Gary Saunders, music by Elnia Nusmanova.